like to speak now as a professor of international law. There are matters, in fact.
That is why you were invited.
Yes. There are matters, in fact, where neither the Senate nor the President can withdraw from. Thank you, Mr. Chairman. The invitation to appear today came very late in the afternoon yesterday, and I had to stand as a sponsor to a wedding in faraway Tanay. No? But in any case, it's a privilege to appear before you. I actually did not expect I could make it at the time that I actually arrived. Now, the issue, I understand, and I was just given a copy of 305, but the issue that I was prepared to appear before this honorable August body is whether or not Senate concurrence is necessary if we were to withdraw from the VFA. And my quick answer is this has been answered by the Supreme Court in the case of Salonga versus Executive Secretary, where I was both a petitioner and counsel for the former Senate President who vetoed Salonga. In brief, the court was very explicit. It said that the VFA was constitutional because it was an implementing agreement of a treaty, which was the Mutual Defense Treaty. And therefore, the court, although it denied our constitutional challenge on the basis of constitutionality, nonetheless upheld our contention that the Romulo-Kearney Agreement was in fact illegal as being contrary to the provisions of the VFA itself. Now, of course, the ruling of the Supreme Court that it is a mere implementing agreement is very important because we know that the language of the Constitution is that only treaties must be concurred in by the Senate. And the Supreme Court was very clear. It may not have been a treaty. It is an ordinary implementing agreement. And this was the court's way of addressing a lacune that its earlier ruling in the case of Bayan versus Zamora had. No? Because in Bayan versus Zamora, they did not squarely address, is this a treaty or an agreement? They merely said, whatever it is recognized as an international agreement by both the Philippine government and the U.S. government. And so they had, on the second occasion, where the same issue was brought to the court, they needed to address that particular issue of, is this the VFA a treaty or not?
But,
yes?
Professor Roque,
yes, Your Honor.
There was no ruling as to whether or not the President can unilaterally terminate a treaty, because that was not an issue there. It was an issue as to whether or not the VFA is a treaty or not, or an executive agreement.
Well, I beg to disagree. In fact, that was what I said in oral argument. In oral argument in the court, I revived the issue of the fact that there are two provisions in the Constitution relative to Senate concurrence. One is a general rule, which is Article 721, that no treaty shall be valid and binding until concurred in by the two-thirds vote of the Senate. And another is 28, Section 25, which says that where we're talking of foreign troops and bases, then it has to be in the form of a treaty duly recognized by the other contracting party as such. And we brought up the issue again of whether or not the VFA, since it was not concurred in by the U.S. Senate, was in fact a treaty which was required to be entered into for purposes of 25 of Article 8, Section 25. And the court said it was not one. And that was why the court had to say it's a mere implementing agreement. So because this was already the second time it was brought to the court had to address that issue precisely and say that it does not require concurrence because it's an implementing agreement of a treaty, and the treaty that was duly ratified by the U.S. and the Philippine Senate was the...
It does not require concurrence because it was not a treaty. But nothing in that case said that the concurrence of the Senate is not necessary in determination.
Well, because the Constitution does not provide that Senate concurrence, Your Honor, is required whenever we are to withdraw from a treaty.
Yes, precisely. That's the legal issue that we are now debating. And the proposed Senate resolution expresses the sense of the Senate that the concurrence of the Senate in the withdrawal is needed because of the principle that the process of ratification and the process of withdrawal should reflect the process of ratification.
But it is my humble submission, Your Honor, that this may be an instance of Senate overreach. Why? Because in the very recent case of the Intellectual Property Association versus Executive Secretary, the court in fact said that it was actually the DFA that will determine whether or not an agreement is a treaty that would require Senate concurrence, or whether or not it is a mere international agreement. And this is still pursuant to Commissioner of Customs versus Eastern Trading, defining what a treaty is, one which formulates a new national policy, whereas an agreement fills in the details of an existing national policy.
Yes, these are distinctions between an agreement and a treaty, but it has nothing to do with the power of the Senate to concur, to require the approval of the Senate in the withdrawal from the treaty. In fact, that's an open question as we debate on it today. And the 305 proposes to put across the sense of the Senate that the withdrawal from treaties would require Senate approval, and that is why we will be asking the Supreme Court to rule on this issue.
Your Honor, again, let me clarify my position. No? Perhaps the reasoning why some senators believe that Senate concurrence is necessary in any instrument that they have concurred in is because the Constitution says before it can be valid and binding, Senate concurrence is needed. This is a requirement, sine qua non, for a treaty to become more or less part of domestic law. But you see, it is not actually the process of legislation. It is only said to be a requirement for a treaty to become valid and binding. It is still not the same as a law enacted by Congress. Why? Because if it were to be exactly a law as enacted by Congress, then the House should have participated in it. The fact that the framers of the Constitution limited the role of the Senate in concurrence in order that a treaty can become valid and binding means that the role of the Senate in this regard is limited to ensuring that as a co-equal branch of government, it functions or it discharges its function to be, you know, a co-equal branch in the exercise of equality of powers between different branches of government. No? The fact that it has not required concurrence also for withdrawal is a recognition that whether or not a treaty continues to serve the national interest is an issue now vested with the chief executive, the executive department.
Yes, Mr. Chair.
Marcos.
Yes, Mr. Chair. May I, for the benefit of the body, just remind ourselves of the Brion concurring opinion in IPAC versus Ochoa,
Your
to
Honor.
which Attorney Roque referred to. Without doubt, the President has the sole authority over the conduct of foreign affairs, and this includes negotiation, ratification, and so on of internal agreements. This is the crux. The President has full discretion, subject only to the limits found in the Constitution. Hence, when you have a lacuna legis, as is clearly the case regarding the abrogation concurrence requirement, I think that, like Attorney Roque, there is no limitation imposed by the Constitution, and hence there is no requirement for Senate concurrence. This, by the way, is the most recent jurisprudence, having come out only in July 19 of 2016, so it supersedes the past, GR number 204605, if you care to keep the citation.
Any other comments? Okay.
Yes, well, I'd like to speak now as a professor of international law. There are matters, in fact,
That is why you were invited.
Yes. There are matters, in fact, where neither the Senate nor the President can withdraw from. And these are customary norms of international law. There are some treaties that restate customary norms, for instance, the prohibition on genocide. And even if the President were to withdraw and the Senate were to concur, that would not be binding on us because customary norms are binding whether or not we agree to be bound thereto. Now, on the specific issue of a formal treaty recognized as such, whether or not the Senate could concur in, that exact same issue now is pending before the court. And this has to do with the withdrawal of the President from the Rome Statute of the ICC. Now, that is in fact, it would in fact be a superfluous issue if the Senate now were to bring the same issue as far as the VFAs is concerned. And that is why in my earlier intervention, I had to distinguish that the VFA, according to the Supreme Court, was not a treaty, a mere international agreement, but the issue on withdrawal from the Rome Statute of the ICC will now determine whether or not the Senate concurrence is required.
We will not bring the BFA. It's the issue of a definition and delineation of constitutional powers insofar as abrogation of treaties is concerned, not at the BFA.
Correct. But you see, oral arguments have already been had on the withdrawal of the country from the Rome Statute of the ICC. And from the interpellations of the justices, it's very clear. There appears to be a consensus amongst the justices where the Constitution is silent, it cannot be implied. And therefore, although the court still has to issue its decision, as far as the Rome Statute of ICC is concerned, that seems to be the consensus on the basis of oral argument. And I did watch the oral arguments online because it's now broadcasted online. No? It is by the Supreme Court. No? And of course, we have to deal with constitutional commitments. No? When the Constitution requires concurrence, it will expressly provide for concurrence. And if it does not provide for concurrence, that means it is not a requirement. Now, I think also one last point is that it is only under Philippine law that we make a distinction between treaties, international agreements. Because under the Vienna Convention on the law of treaties, it does not matter what you call it. For as long as the three elements of a treaty are present, then it is a treaty. But we make a distinction precisely because of the two provisions in our Constitution that when it comes to stationing foreign troops and bases, then it can only be allowed in the form of a true treaty duly recognized by the other contracting party as such. But this distinction does not exist under international law for as long as the three elements are concerned. So now we're talking actually not of an issue of international law, but an issue of constitutional law. Thank you, Mr. Chairman.
Thank you.